For everyone joining, we are just going to give it a few moments to allow people a couple minutes to get on, a little bit of padded time there, and then we will get started. Okay, it's about 1 past. We're going to give it about 1 more minute for people to join, and then Kevin will kick us off. All right, Kevin, if you'd like to start.
Hello, everyone, and welcome to the Ohio Chamber's July Business Academy webinar. As Megan mentioned, my name is Kevin Shimp, and I'm the Ohio Chamber's General Counsel. We are excited to welcome you and our guest presenter today, Joseph Caligiuri. Sorry, Joe. Joe is the Ohio Supreme Court's Chief Disciplinary Counsel, where he has worked since 2002. He is responsible for investigating and prosecuting lawyers and judges accused of ethical misconduct. He is a frequent lecturer at the Ohio Judicial College, the Ohio State Bar Association, and the Association for Judicial Disciplinary Counsel. Joe is also an adjunct professor of law at the Ohio State University, where he teaches professional responsibility. He is a former prosecutor in Buffalo, New York, and a graduate of New England Law College and the Clemson University MBA program. We're excited to have him here. He will be sharing with us the ethical consideration that all lawyers need to consider when representing their business clients. So with that, Joe, I want to turn it over to you.
All right. Thank you very much, Kevin. I appreciate it. And welcome, everyone. Happy to be here today. Virtually again. I know this is kind of the new normal. It is very convenient, but there's always something to be said too for meeting in person. So if we ever get the chance to meet, please introduce yourself. I'd be honored to meet you in person sometime. So today, as Kevin mentioned, we're going to talk about some ethical issues and professionalism issues that we see here from our perspective in the Office of Disciplinary Counsel, both a lot with lawyer cases. That's the majority of what we do. We also investigate, prosecute, educate the judiciary consisting of judges and magistrates. But today we're going to focus on issues facing the legal profession, some cases that I thought might be interesting for this group, since many of you deal in your legal practice, deal with representing business entities or clients that have a business background. So I'm going to talk about a couple of cases and then a couple of stories in between here and there that may have grown out of these cases. And then I want to talk a little bit about professionalism and some of the issues that we're seeing in the profession, much of which will not be a surprise to you, although some of the numbers can get a little bit staggering at times. So what I'm going to do to start out is just share my screen over here. Switch over to that view, move this over here so I can see. Okay, so hopefully you can see my PowerPoint presentation over here, just called Ethics and Professionalism. The first thing that I actually wanted to talk about deals with our ethics hotline. This is something that I really like to promote, and for two reasons, actually. One is I don't think a lot of lawyers know that the Office of Disciplinary Counsel has this service available to them. And we like to call it an ethics hotline because it is manned every day by one of our assistant disciplinary counsel. Myself and my chief assistant, we man the judicial ethics hotline. So any judge or magistrate that might have an ethical issue, they're going to get routed to either me or the chief assistant. And then the attorneys in the state of Ohio can call this number 387-9700. And they actually will get one of the assistant disciplinary counsel if they're not there, possibly me or my chief assistant as well. And I really enjoy this service that we offer, both for the practitioners like yourselves, but also for us too, because we sit in here and we're kind of a defensive type of an agency. In other words, we're reactive, I should say. We get complaints in, and then we act on them, whether it's through education or investigation and prosecution. But the ethics hotline kind of gives us an opportunity to act in advance or prophylactically, because somebody is coming to us with an issue and they're looking for guidance before something unethical might occur. So they're trying to avoid a situation. So for us, it's a benefit because we get to see what's going on out in the street, so to speak. And for you get the benefit of a disinterested person. And although we can't really give legal advice, oftentimes we found that it's helpful just for the lawyers to be able to voice the concern that they're having to someone who's objective and someone that has some experience in this ethical arena. And I bet many of you would agree that so many of the issues that come up in your practices probably involve conflicts of interest, especially when you're representing corporate clients, whether they're small entities or larger entities. And so, you might call and say, hey, can I take on this representation? And oftentimes what we do is, the first thing we do is we get out our legal pad and start drawing lines between the parties, trying to figure out where the conflict might lie and who actually the client is. And so I just like to tell people right up front that you can call that anytime. If the person doesn't answer the phone immediately, just leave a message. And, we have a policy here, all calls must be returned within 24 hours. And usually that's a long time. So we'll get back to you. And sometimes we have to do a little research. We'll look at advisory opinions. We'll look up some old cases to try and give you some guidance on which way you might want to go. But most of the time, it's just the benefit of knowing that you can talk out a problem with somebody that's not going to judge where you're at on it necessarily. And then usually the person ends up coming to the decision on their own, just having considered maybe some of the rules that we've talked about during the call. So please don't ever hesitate to call our office if you have a question. It's much better to make those calls before you take action than after, because then the stakes are a bit different once the consequences have occurred. Okay, so we talked a little bit about what we want to talk about today, and I want to start with a case that is relatively recent. This Columbus Bar Association versus Polly Murphy, which came out about six or 7 months ago. And this case was kind of I would say like on the spectrum of the popularity or notoriety, definitely on the low end. But I like this case for a number of reasons. And in fact, if you read the opinion of this case, it's just a few pages long, but there's actually a lot of issues in it, despite a relatively small recitation of what actually happened in the case, what gave rise to the misconduct. So this was a Columbus Bar Association case. As many of you know, our office handles investigations and prosecutions of lawyers and judges, of course. But we also have 32 or 31 now certified grievance committees throughout the state, and they prosecute mostly lawyers. The Ohio State Bar Association will prosecute judges as well. So they have the same type of jurisdiction, although it's limited geographically, except for OSBA. So Columbus Bar will handle cases that are brought here in Columbus. People can file with the Columbus Bar, or they can file with our office. It really doesn't matter. So they brought this case and prosecuted it last year. And again, I thought it would be relevant for this group. So, okay. So Polly Murphy was an associate in a mid-sized law firm. And as part of her duties there, she assisted a friend in setting up a corporation, which is called AHB. And they were in the business, like a healthcare company, in the business of these transdermal patches for, for patients. And so, because this was a friend and it was a small startup, they offered her compensation in stock ownership, which is really not all that uncommon, especially when you're dealing with startup companies and you're dealing with people that might have cash issues right up front, but the future looks bright. And so they may work out an arrangement with counsel that instead of paying cash for legal services, they're going to provide you with an ownership interest in the form of their corporate stock. So Polly Murphy ended up accepting this arrangement of payment through basically 1% ownership in the company. And she performed legal work. I would say on par of like a general counsel, but probably at a much reduced level. This was more about getting the corporation set up, shareholder agreements and things like that. Well, as the business grew, there was another company for which this lawyer provided legal service as well. That company was, I'm just referring to it here as NB Nutrabrand. And NB was in a similar healthcare industry, pharma type company, and they were interested in acquiring AHB. And for the most part, the lawyer in the case ended up handling that acquisition on behalf of AHB and NB. So right there, one of the things that you might want to consider, just given that limited number of facts, is dual representation of both entities and what types of conflicts could that potentially bring up, and whether or not you can act by providing independent legal judgment to both entities in an acquisition situation. So at any rate, during this process, the SEC opened an investigation on NB, so the other client, and they were seeking information about NB's impending acquisition of AHB. And as part of that inquisition, the NB asked Polly Murphy for a legal opinion regarding some FDA requirements in AHB's products, these transdermal patches. And she provided a legal opinion that actually was erroneous. Basically, it said that the product was exempt from FDA regulation and FDA approval, and that simply wasn't the case. But she did send that opinion over to NB, the other client, on her firm's letterhead. NB then forwarded that information over to the SEC, and the lawyer ended up also writing a bunch of letters regarding shareholder redemption and shareholder referral agreements, shareholder exchanges, on her law firm letterhead as well. Well, unfortunately, because of that erroneous legal advice, the SEC proceeded with litigation, and ultimately the second client, NB, was fined $25,000 by the SEC. And then they brought NB, the second client, brought a malpractice action against the firm, okay, that this attorney worked for and the attorney. Okay, so basically what you have right there, even though this is a kind of a bare bones fact pattern, it's kind of chock full of all sorts of problems, and I'm going to talk through a few of them on the next few minutes. So the first thing that you would need to know is, well, we're talking about fees here, and what type of fee agreements did we have? Well, we know that the fee agreement with AHB was this 1% ownership. The fee agreement with NB was a similar arrangement, because what ended up happening was the acquisition went through, and the lawyer was instrumental in that. And basically, the lawyer's ownership interest from AHB just transferred to NB, so that she was a 1% owner in this new company that had acquired AHB. But NB also paid her $5,000 for her legal work on behalf of NB, and they deposited that by direct payment into her personal checking account. Okay, so in addition to the stock ownership, she received this $5,000 payment, and that's going to come up in just a minute. So basically, when this malpractice action happened, that was against both the lawyer and the law firm. The problem was that the law firm didn't know that this attorney was in fact working on behalf of AHB and NB. In fact, they had no idea that they were quote unquote a client of their firm, because the lawyer never advised her law firm that she was doing this work. Remember, it started out as work for a friend, setting up this corporation, AHB. So what went wrong is a lot of things in this little fact pattern. The first thing is that there was this conflict of interest. And you might be thinking, well, the conflict is going to be that you have one firm acquiring another firm, and you're acting for counsel for both. And that could be a potential conflict. It could also be a conflict that may be waivable under certain circumstances, but that's not what this decision focused on. What this decision focused on was this payment arrangement that is fairly common between lawyers and these small entities that are in their startup phase, where they're going to take stock ownership in lieu of cash because they're cash strapped, or maybe it's just the way they want to do things. And it's attractive to the lawyer as well, because there's the possibility of this 1% ownership could actually result in a windfall of some sort should this company be acquired or hit it really big. So you might be thinking, well, what's the problem? The problem is that under our rules, anytime you accept anything other than cash as payment for your fees, it triggers certain rules and requirements that you have to meet. And so that's the first thing that we're going to talk about. Then the second thing are the legal fees, which ties it right back into this whole conflict because that's what it's around. And then her responsibilities to her law firm, because as I mentioned, she didn't disclose to her firm that she had this client on the side. And of course, that could be permissible in situations, but you're going to want to have that type of arrangement in writing where you can bring in your own clients. Okay. And then the fourth thing would be, was the representation that she provided to AHB and NB competent representation under the rules? And I think that's kind of an interesting rule violation in this case, one that I think we can dive into a little bit. All right, so let's start with the conflict of interest. So under our rules, most of the time when you're looking at a conflict, you're looking at rule 1.7. And that's kind of the starting point for all conflicts, because that lays out a roadmap to evaluate whether or not you're in conflict territory and whether you have to either get a waiver or get off the case. And so 1.7 is kind of divided up. It basically is, do I have a conflict is the first part. The second part is, if I have a conflict, is it waivable? And then the third part is, am I sure that it's waivable? Because some conflicts prohibit representation no matter what. In other words, you can't get a waiver for certain types of conflicts. So I always tell people when you're faced with these types of situations where you're looking at a conflict, start at 1.7 and just walk yourself through the rule. Most of the time, you're going to arrive at the answer. This problem, as you can see from the screen, involves 1.8, which is the next section. And 1.8 was basically developed because these were types of conflicts that we were seeing on a much more frequent basis. So rather than just keep everything codified under this general 1.7 framework, we broke it out and we listed 7 or 8 situations which lawyers seem to encounter quite frequently. We just basically said, hey, if you encounter this situation, this is what you need to do. And so when you look at 1.8a, that talks about business transactions with a client. All right. And what I like to tell lawyers is basically anytime you're getting anything other than cash for your representation, 1.8a is going to be implicated. Okay. So, if somebody comes in and says, well, hey, I got this 1956 Corvette that I'll give you in return for the representation, you can take it. You just got to follow through 1.8a. Same thing in this case with the stock or ownership agreement, which was 1% of the company through stock. And so 1.8 requires these 3 elements that we have to meet. The first one, and these are the thing about conflicts
Hey,
is,
Joe, before you get into the elements, there's a question in the chat related to the attorney and whether or not she was an employee of the firm.
yes, the attorney was an associate employee. Thank you. But the attorney was an associate employee of the law firm. And she was also part owner of the company, AHB, and was on the board of AHB as well.
Thanks, Joe.
Yep. So a lot of these conflicts cases, like they're complicated in the fact patterns, but when you actually get to the conflicts, usually once you understand it's all about your loyalty to one client and identifying who your client is, you can usually arrive at the solution, which is either, again, waiver, disclosure, or, I just can't take this representation. So in this case, you want the stock, okay? So you have to walk through these criteria, and they're kind of common sense. The first one is that the terms of the compensation agreement have to be fair and reasonable. Well, that should be pretty obvious. Anything that's unfair or unreasonable is going to cause you problems ethically, okay? It has to be disclosed to the client in writing, all right? The terms of the compensation have to be reasonably understood by the client. So this is all under one criteria, but it's really broken up into 3 different subsections: fair and reasonable terms, disclosed in writing, and it has to be in language understood by the client. So I like to give one example that's kind of apart from this conflict issue, but I had a situation several years ago, and a lawyer called on the attorney hotline, so to speak, and I took the call, and he was talking about this business client that he had, and he had represented this business for a long time, but the business was kind of taking a turn and going in a different direction, and they were anticipating some greater legal needs that had come up in the past. And so the client approached the lawyer about kind of being on this like retainer agreement, and there was basically going to be like a monthly legal fee. Whether or not it was used or not, they were going to pay this like flat fee, so to speak, every month. And the lawyer was concerned about it, and rightly so. There were some issues with it. And he said to me at the end of the call, would you mind if I sent you a copy of the fee agreement that I'm going to give to my client to look it over before we actually execute it? And I said, yeah, no problem. So he, just to give you an idea, it was quite a while ago, he faxed it over, and it came out 7 pages, single spaced, no paragraphs. And I didn't even read it. I started reading it, and I just said, no, like this is not language that's going to be reasonably understood by the client. If you're taking 7 pages, single spaced, no paragraphs to explain your fee agreement, it's too complicated. It's not going to help you avoid an ethical dilemma when you're called to defend this fee arrangement with the client. All right. So even though that really doesn't fit in with 1.8A, because this wasn't a compensation other than cash in my hypo, it's the same type of logic applies here. If you're constructing an agreement with your client that's so convoluted that the client really has no idea what they're entering into, that's going to implicate this 1.8A subsection 1 here, and it's going to be problematic. Okay. The second thing that the lawyer needs to do is you have to advise the client of the opportunity to seek an independent lawyer and provide a reasonable time for that person to do so. And usually what we see in this situation is that the client comes back and says, well, I don't want to talk to a lawyer. You're my lawyer. I trust you. And that's where you have to say, the rules prohibit me from doing this unless I tell you that you have to seek independent counsel, or you have to give them the opportunity, to seek independent counsel. And you got to give them time to do it. Okay. So that's, again, really to protect you from a subsequent claim of overreaching or coercion, because you have the knowledge and the experience on these types of arrangements. Your client may or may not. Now, the more sophisticated the client is, the more you can take some liberties with this. Like you might have a client that has done these arrangements with 7 different lawyers. Okay. And so, hey, by the way, you need to speak to independent counsel, and they call you and say, yeah, I understand that, but let's get this done by Friday. Well, it's Monday, 5 days might be reasonable. But for somebody that's never done that before, they might need 5 days just to find a lawyer. Okay. So it's kind of dependent on the circumstances, but this rule is really intended, this part of the rule is intended to protect you. This is a way for you to cover your actions to make sure they're above board. And then the third thing is the client has to give informed consent in writing, signed by the client, as to the terms of the deal, so the financial ramifications, and then the lawyer's role, in that compensation package. In other words, is the lawyer going to be representing you on this? Or are they just now going to be an owner of the company? Like in our example with the case that we're talking about, this person was actually on the board of the company and acting as the lawyer. Okay. Informed consent. I think as lawyers, we just kind of gloss over what that means. And what I tell people is you have to give the client enough information that they actually understand what they are consenting to. Again, it's easy to get lost in this fact that you have all the knowledge and the experience. And so sometimes what seems very simple and clear to you might be confusing to your client, especially if it's the first time they've entered into this type of arrangement. All right, so what we know about this case is that none of that happened. So the lawyer in that case just basically wrote up the agreement, everybody agreed on it, and that was it. There was nothing to support the fact that she went through these steps before entering the arrangement. That's why these things need to be in writing, because this didn't happen in this case, but there could be testimony that, oh, well, we talked about all this. We talked about the terms, we went out for dinner, we hashed all this out. Gotta be in writing, okay? It doesn't do anybody any good if there were discussions about it, but there's nothing to confirm compliance with this rule. All right, so that issue ended up being problematic for this lawyer, and she was found to have violated Rule 1.8A, entering into a business transaction with a client, and actually with 2 clients, because the first client was AHB, and then when they did the shareholder swap, she ended up getting 1% ownership interest in the new company. So it was really the same violation 2 different times. Okay, so that's the conflict end of it. How about competence? Well, actually, before I get to competence, I want to talk about the fees for just a minute. So we talked about the second company paying $5,000 in fees, okay, for the legal work. All right, that was right before they ended up initiating the lawsuit. Well, as somebody asked, the lawyer was an employee of this firm, and there was certain policies in the firm with regard to bringing in new clients. And as you can imagine, it was pretty much standard. That you advise the firm of the client that you're bringing in, because the firm has to perform conflicts checks to make sure that you can take on the representation without violating these other rules, like 1.7. All right. And then, of course, there's going to be a fee structure. You're an associate in the firm. Well, the partners in the firm are going to be compensated off of the fees that you generate based upon your representation of this client. Okay. And so this person did not disclose the fact that they were working on this friend's case, and they didn't disclose the fact that the second company had paid the lawyer $5,000 cash into a personal checking account. All right, so that was against firm policy. And it's interesting because you might think, yeah, well, it's only $5,000, or, the firm should have been more proactive in monitoring this type of stuff. This falls squarely on the lawyer. And I think in this particular case, that was the most serious allegation in the case. What happened between the lawyer and the 2 corporate entities was a conflict, and that's certainly misconduct. But the issue with the $5,000, that's more dishonest conduct, bordering theft. It actually is theft, because the lawyer knew that the firm was entitled to a percentage of that $5,000, and potentially, at least disclosing this other financial arrangements so that the firm could figure out how they were going to be compensated for her working on these clients. And of course, then you're working on these matters on firm time as well. So that's what we call an 8.4C violation, which is any conduct involving fraud, dishonesty, deceit, or misrepresentation. And when you have a charge of 8.4C, that really takes your technical type of misconduct, for instance, the legal fee, into a different realm. You know, you're going from what would be a reprimand to potentially losing your license because of dishonest conduct. And there's case law that says, and this goes back over 20 years, if you engage in a pattern of dishonest conduct, you will lose your license to practice law for a minimum of 6 months. And we rely on that case a lot when we have these 8.4C dishonest conduct cases. And the court has always taken it very seriously when lawyers, you know, steal, so to speak, from their firms. All right. There's really no difference than stealing from your firm by not disclosing the fact that you're bringing in this business versus stealing from a client. Okay. So it's serious. So this lawyer ended up with an 8.4C violation in addition to the 1.8A violation. All right. So that ends up taking this case to just a different level, so to speak. All right, then the third issue was this competence issue. And I thought this was really interesting. Again, it's not really developed much in the case, but the competence charge is a 1.1 violation. And under Rule 1.1, which it's short, I'll read it here. It says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Okay. You don't really see 1.1 charged all that much in disciplinary cases. Why not? Well, most of the time when we're dealing with whether or not we're asking the question, you know, was this lawyer negligent or was this lawyer incompetent or both? And usually if it's just a matter of work product, we're going to err on the side of caution from a disciplinary standpoint. We're going to say, you know, that's more negligence, malpractice. That's something that's going to be addressed in the civil arena. And here, of course, there was a malpractice action against the lawyer, which ultimately was settled out of court. But nonetheless, that was part of their civil litigation and part of this case. But here the lawyer was found to have violated 1.1, and the court found that the reason why was because she provided this erroneous legal opinion. And it's interesting because this case was a stipulated case. So that meaning that the lawyer agreed up front that she engaged in this misconduct and violated the 3 disciplinary rules, the 1.8, the 8.4C, and the 1.1. So it would have been interesting if the lawyer would have contested the 1.1 and gone in with a defense of something to the effect of, well, you know, it was a genuine mistake on my part. It was legal error. I wasn't trying to dupe anyone or anything like that. It's just I made a mistake. But because she stipulated to it, we really don't know necessarily what all the facts were behind it. But the opinion suggests the 1.1 is based strictly or solely on that erroneous legal opinion that she provided to the client, which I think would, most of the time, like in our office, we probably wouldn't prosecute that, but there may have been facts that just didn't make it into this opinion that we don't know about. So that the competence issue is just, it's unique. It's just not in a lot of cases. So at the end of the day, this lawyer, for this $5,000 payment and this 1% ownership interest in the company, ends up with professional discipline. And the court issued a 1-year suspension of her law license fully stayed, meaning that it's kind of like you're on probation. You've been found to have committed misconduct. You lose your license in a sense, but you stay. In other words, if you don't commit any further misconduct during that year, then you get to keep your license and keep practicing. That's why I say it's kind of like probation. Now, interestingly, this was a 4-3 decision in which 3 justices dissented and would have opted for a greater sanction of 18 months versus 12 months, although they still would have stayed it. And the reason why I think it's interesting is because the 8.4C sometimes can act as that amplifier in your misconduct, that aggravating factor, to take it from this potentially stayed suspension where you can keep practicing law to an actual suspension. And I think in this case, what kept this at a state suspension were the mitigating factors. First of all, this person had no previous discipline and had been practicing, I think it was about 20 years at the time of the misconduct. Second, there was full and free disclosure. That's such a huge mitigating factor. I don't think lawyers understand how important it is to, once you're in this system, to kind of have some introspection and cooperate in the process. It really makes a big difference when it comes to appearing in front of the panel and then ultimately the case going to the Supreme Court. Third, there was restitution made. Now, there's not a dollar amount in the opinion, but the malpractice action was settled, so there was that. And then I'm assuming that the $5,000 or whatever percentage of that would have gone to the firm had the lawyer been honest with the firm about the legal work. I'm sure that was repaid as well. And that in restitution in these cases has to be timely. You can't just do it at the last minute. It's got to be right up front, because that shows you're recognizing what happened. And then finally, the court found that there was genuine remorse for her actions. And the reality of it is we all make mistakes, all right? But what makes a difference in disciplinary hearings is, are you going to own the mistake, or are you going to try and deflect blame and continue to deny it? And sometimes that's tricky for lawyers because, they may feel like they didn't do anything wrong and they want to fight this. And that's okay. You have that right, but you always run that risk of, well, if it doesn't go your way, in other words, if you're not quote unquote acquitted, then, you run the risk of them, the panel and the court, looking at this as someone who's not acknowledging the wrongful nature of the misconduct. And here, this case was stipulated right up front. So it was obvious that the lawyer was there. She knew she made some mistakes, some errors in judgment. She was going to have to pay the piper through a suspension. So, a short little opinion, but it's kind of chock full of conduct in this case, which I think is relevant to what a lot of us do.
Great. And Joe, thanks for that rundown. There was one question that I want to give you an opportunity to respond to. It does relate to a specific advisory opinion, so you may not recall all the facts to it. But want to at least give the opportunity for the question to be responded to. And it mentions advisory opinion 2020-10 from the Ohio Board of Professional Conduct that addressed whether different lawyers from the same law firm can represent both sides to a transaction with client consent and appropriate ethical screening. It concluded that law firms cannot do that. And so, the question says the speaker indicated that perhaps the firms can represent both sides and asked for you to clarify. So I want to give you an opportunity to respond.
Yeah, no, that opinion's correct. If you're on different sides of the same transaction, you're not going to be able to do that. There are some situations out there where you've had subsidiaries like attenuated enough to be able to pull off that type of representation. But the general rule, which I think has been upheld time and time again, is if you're on opposite sides of the transaction, you're not going to be able to do that. So that is correct advice.
Great. And before we move on, just want to do a little housekeeping now that we have about 20 minutes left. So for everyone that's attending today's webinar, you will receive an email from the Ohio Chamber that includes a survey. In the survey, it'll ask for your attorney registration number and for you to provide a challenge word that verifies to the Supreme Court that you attended the full webinar. So we'll provide that challenge coin right around challenge word right around 1 o'clock. So just wanted to make sure everyone was aware of that. So go ahead, Joe.
All right, thanks. All right, so the second case that I wanted to talk about, I'm going to kind of blow through this one a little. It gets a little in the weeds with just all the different companies, but it's the same type of thing, but some different issues in there, which I think are important as well. But this case, some of it occurred under the old rules, our disciplinary rules, but the same concepts apply. In fact, I just kind of converted them into the new rules because they're so similar. But this involved a software company called TSI Holdings, and then a small boutique law firm that was kind of interested in providing seed capital to new startups back like in the tech craze. So I'll run through it just a little bit. The client's name was Brian B.S. He owned TSI, which was a software tech company. And they were basically in the business of assisting Fortune 500 companies with event registration. And they were booming at the time. But then he took over, acquired a marketing firm, and there wasn't due diligence done on the books. And it turned out to be an accounting financial nightmare that really brought TSI to the brink of bankruptcy. And it was just a really bad situation because the company was really on the up and up, but then they had this ill-advised acquisition and things went south in a hurry. So Brian B.S. reaches out to this firm, Cowden and Nagorny, and to talk about the viability of TSI going forward. He wanted to make sure he could pay his employees, that he was set financially. So they enter into this agreement to represent TSI. There was a question as to whether or not, I'm just calling it CN, that's the Cowden and Nagorny, whether or not CN represented Brian individually as well. He ended up in the disciplinary hearing testifying that he felt that they were his personal attorneys. And we did pitch that theory in our case because I believed it as well. But ultimately, that the court didn't find that there was personal representation because he did have another lawyer, even though Cowden and Nagorny oversaw some of that representation. It was blurry at best. And it was not another example of why you always want to cover yourself as to identifying who your client is, especially when you're getting involved with entities, small entities, where the sole shareholder is you're representing the client, the business, not the sole shareholder, but the sole shareholder identifies with that business because it's his or her life. And of course they think you're representing them too. If the onus is on you as the lawyer to say, hey, I'll do this, but I only represent TSI, I don't represent you personally. There was never any of that communication. And the lawyers, in my opinion, were lucky to not have been found to have represented him personally, because that would have opened up more conflicts. But at any rate, they come in right away and they negotiate some forbearance agreements with Huntington National Bank that reduced Brian's personal guarantee pretty significantly. And then they introduced Brian to this entity called Hockey Stick, which were some friends of the lawyers, Feisty and Ganshorn. And one of the lawyers, Cowden, ended up owning a 7.5% stake in Hockey Stick, but never disclosed that to Brian, okay? And that'll come up in a second. So eventually they work out this pretty complex business deal, like a secured party sale of TSI, which we'll call old TSI. And then they sell it to TSI Holdings, which was owned by Hockey Stick and therefore owned by one of the lawyers, at least on a percentage basis, for some money. And then ultimately that company gets sold to this new TSI, and the firm takes a 30% stake through stock in the new company. All right. Now, Cowden and Nagorny were counsel to old TSI, TSI Holdings, new TSI, and Hockey Stick. So you could see right away, this is like fraught with potential conflicts of interest. And so right away, you're implementing again 1.8A, and I won't go through all that again, but that was not done in this situation. Okay, there was disclosure, and there were terms that which was a sophisticated businessman, but he was also in the middle of his company going from up top to impending bankruptcy. Was in a really tough spot, a lot of pressure. Really trusted the advice of his lawyers, and just wasn't clear on who was doing what, who owned what, who was representing who. So it got pretty confusing. All right. So here's the interesting thing. The lawyers actually did some things right, okay? They did have the terms of the agreed upon sale, the terms of the sale agreed upon, and they did advise the client, Brian, to seek another lawyer. But here's the situation and why it didn't work. Remember, we talked about that lawyer having to be independent, okay, and having to have a reasonable opportunity to seek independent counsel. Well, as often happens, and why you need to be aware of this, is that the clients trust the lawyers. And so when the lawyer said, hey, you got to speak to another lawyer, the client said, okay, who do I speak to? And the lawyer said, I want you to go see this guy, Robert. Okay. And so the client goes to see Robert, but the lawyer never told Brian that Robert was being recruited by the firm. So Cowden was recruiting Robert to come work for the firm. So he wasn't independent. This was somebody that had a reason to rubber stamp this deal. The second thing was they really didn't give him time to look at this project, because by the time Robert, the other lawyer, got involved and looked at the deal, everyone had already signed it. It was literally a signed deal. The bank, Huntington, Hockey Stick, Cowden, Brian, everybody was signed off on it. So really this quote unquote independent lawyer was really just a rubber stamp. And he even testified at the hearing like, hey, I did look at the agreement and I did exercise my independent judgment, but it was already a done deal when I got it. So there really wasn't anything for me to do, which really hurt Cowden and Gorney, because they were trying to say that, yeah, we were recruiting him, but we assumed that he would exercise his independent judgment. That wasn't going to fly based upon that language in 1.8. Okay. And of course, you can understand what ends up happening in these cases. Things don't work out as planned. And that's why everything falls back on the lawyer and whether or not they actually went through the appropriate steps and got the client's informed consent. But ultimately, what happened was Brian's company, New TSI, ends up defaulting. Okay. And then Cowden gets off the case and tells him, hey, you defaulted. I'm not going to be able to represent you anymore. But before he does that, he lets his buddies from Hockey Stick and this Basai and Ganshorn loan money through a factoring agreement, which was basically just an infusion of capital in return for accounts receivables, to allow this New TSI company to keep operating for a few months, make payroll, hoping the payday will come. Well, Nagorny, the other lawyer in Cowden and Nagorny's firm, he ends up drafting the factoring agreement between New TSI, which Brian still owns 65% of it, and this other company, Gans Corp, of which Cowden owned 7.5% of. Nagorny didn't even know that Cowden was part owner of Hockey Stick. So he drafts this factoring agreement, and sure enough, Brian and New TSA default on the factoring agreement. And then Nagorny ends up drafting a letter on behalf of Gans Corp threatening to collect under the agreement. And basically it's one lawyer going against his former client, or current client at the time, and threatening to collect judgment against him on behalf of his buddy Gansmore. So both of these lawyers got into this really deep. The issue in the case ended up being the sanction, because the conflicts were pretty obvious. Even though they fought it pretty hard, the conflicts were there, and there just wasn't a paper trail explaining all the different relationships. And so they both ended up getting disciplined. And again, they ended up with state suspensions, one being a 1 year for Cowden because he was kind of the ringleader. Nagorny was 6 months. And they had to pay back some of the fees, and there was some conditions on the suspension, which is usually just commit no further misconduct, and they did, that we were aware of. But the reason why I like this case is because they had the right concept, in that we can't just ram this down the guy's throat. We got to get another lawyer involved. But they took a shortcut and short-circuited the system by sending him to somebody that they were already affiliated with. And that then really caused them to appear in a negative light, because it appears sinister at that point. Like, why wouldn't you just refer him to somebody that was independent? Like, if the deal is fair, that's what you do. So when you get entangled up in one of these disciplinary cases, you end up having to fight that perception, even though it might have just, their argument was they never really thought of it that way, but it has a real bad appearance of impropriety or some nefarious activity. All right, so that's that case. Now, the last 10 minutes, I'd like to switch gears here completely and talk a little bit about professionalism and the possibility of burnout. In preparing for this, I was looking up this old case with Cowden and Nagorny that I had happened to handle, and I was thinking about, that was about 10 years ago or whatever, and I was looking through some old material that I keep with law firm salaries and stuff like that. And 6 years ago, I had talked about professionalism and burnout. And I had found in my resources that the coastal law firms, so the big firms, your New York and California type firms, were paying first year associates $165,000. So anyway, I did a little research in the past week, and that number is now $200,000 for coastal firms, so the big firms, associates. And I just thought that was interesting in that short of time, there's been that type of jump in salaries for new associates. So what does that mean? Obviously, that's not the case here in Ohio, but there are some larger firms here that are paying $165,000, $175,000, and they're looking for billable hours in the range of 2,400 hours. That's a lot of hours, right? And that's going to lead to burnout pretty quickly. I teach as Kevin mentioned in the beginning, I teach ethics over at the law school, and every year, I ask, how many lawyers are going into government practice, public defender's office, prosecutor's office, legal aid, things like that. This year was the first year that literally had not one person raise their hand. And I attribute that to several things, but one of them is debt. That kids are coming out of school with a lot of law school debt or undergraduate debt or both, and those jobs at the prosecutor's office just aren't going to cut it. And so you forego these opportunities to learn a lot in these gigs, and you get into these firms, but you don't really know what you're getting into. And the first thing that they encounter is this billable hour and what impact that has. Now, this year I asked my class, the highest number that I got in class was 2,100 this year, that someone was going to work in a firm that was requiring 2,100 hours. So I've had upwards of 2,400 over the years. That's here, okay? So even though this article that I'm taking this information from was written about the big firms, the author of the article was in a firm that required 1,890, so 1,890 hours. That's still a lot of hours, but doable. And he explains it as, that's basically the difference between no life and a life. But some of these firms are asking for these 2,200 hours. That's 8 billable hours a day, 6 days a week for 50 weeks. So you get your 2 weeks vacation, but you're working 6 days a week. That's billable hours. And you all know that how many hours you actually have to work in order to be able to bill 8 hours a day. It's a heck of a lot more than 8 hours a day. And that leads to this imbalanced life-work situation. And what we're seeing in the profession, and what it's always been there, but it's getting worse, is that the younger segment of our population is starting to experience some of these burnout issues and the consequences of burnout a lot quicker. So basically, you have the hour in the rat race, the hours that you're required or asked to meet. And then the partnership track, when you start, it's like, 6, 7 years, but then it turns out that's just for a non-equity partner. And it's time and time before you ever make it to partner where you might be able to reap some of the financial rewards. Because despite the new salary, when you break that down into your hourly component, it's just not that attractive, especially for what you're giving up. And then as you get more experience in the firms start wanting you to engage in pro bono work or mentoring other lawyers or attending bar functions or joining the chamber or whatever it may be. And you got to figure out how to work that into your schedule and still maintain some semblance of a life work balance. And I think that this type of structure really hurts the professionalism aspect of our profession, because a lot of lawyers they're not in a good place mentally, and a lot of it's from the toxic work environment. And when I say toxic, I'm not necessarily referring to harassment type issues. It's just that there's a lot expected out of these young associates in terms of hourly billing. And it really creates a tough dynamic for them to operate in, and it reflects in their work and the way they treat counsel and judges. You'd be shocked at the type of stuff that comes in here that doesn't make it into a disciplinary case because it's not worthy of that. But we do a lot of educating on professionalism. And, you know, I ask lawyers all the time, have you looked at the lawyer's creed and what it says? And everyone's like, what? The lawyer's creed? You know, there's so much strong aspirational language in there that if we just took a minute to actually read it, think about it, digest it, and live it, it'd be such a better profession. But we don't, because we're always fighting against trying to get more hours in. And of course, that leads to people fudging the numbers. It happens all the time. You work in these firms and, you know, you're expected to bill 2,000 hours a year. And you just start out like, well, what do I need to do to get to 2,000? This is what I'm going to do every day. And you start, you know, just fudging a little bit, you know, 0.6 here, 0.3 there. Well, all of a sudden it's 2 hours a day that you're not working, but you're billing for. And it's a really slippery slope. And a lot of lawyers, unfortunately, are still experiencing that in even some of our local firms. So I think that this type of situation, when you look at these numbers, it actually contributes to the public's perception of lawyers as not necessarily being the most honest of professions. I mean, I looked at this survey that the Columbus Bar had done. This has to be 10 years ago. And the profession with the most honest and ethical principles was nursing, received 84%. And the least was members of Congress, no surprise, 7%. And lawyers were in at 19%. And I thought, God, that's, you know, it's not the worst, but 19%, you know, that's just brutal. And why is it? Well, a lot of it's billing. You know, so many of the cases that we get in say my lawyer overcharged for X. Now, most of the time, it's hard for us to determine whether or not there was overcharging, or even if there was, our standard is that it has to be clearly excessive. Okay, so we're not going to bring a case that's a fee dispute, but we get a ton of them in, and they just reflect poorly on the profession. Most of the time, it's the lack of using written fee agreements. So clients get these bills at the end of the representation, and they're shocked because that's not what they thought they agreed on orally. There's nothing that they can point to that's in writing to confirm what the original agreement was. And they weren't they weren't getting invoices every month or every 2 weeks or every 3 months, whatever it was, from the lawyer. So they're shocked, and the first thing they want to do is complain. So we have to deal with a lot of those, and it creates this negative perception of the profession as a whole, when only a small number of lawyers are doing it. But there's a lot of pressure on lawyers to bill, and that makes its way in to fraudulent billing. Okay, and even though we might not be able to prove it from a clearly excessive standpoint, it still gives the profession a black eye. This 2016 Hazelden study on lawyer well-being, I thought, was phenomenal. You should read it if you have a chance. But the thing that struck me was younger lawyers are at significantly greater risk than lawyers practicing more than 15 years. This is alcohol abuse. And I've been doing this for 20 years, and I would have said, if somebody said, you know, where's the alcohol abuse? I would have said it was lawyers over 15 years, hands down. But this kind of tells me, and this is just anecdotal, that the previous screen with the hours and what's expected of newer associates is having a direct correlation to this improper life-work balance and this occurrence of mental health conditions like anxiety, depression, and substance abuse in the younger lawyers. And so, you know, the question is like, well, what can we do to help this? And I think the first thing you could do, again, is maybe not today, but over the weekend or something, go read the Lawyer's Creed. You know, it's so inspirational at times on what the profession was supposed to be like. And if you can get back to some of those basics, it's going to make a difference, not just for you, but in your firm or in your company, wherever you're at. Get involved in the lawyer-to-lawyer mentoring program. That's really helpful for younger lawyers. And you're going to find out, if you're a good mentor, whether or not your lawyer, your mentee, is struggling with some of these issues. And you might be able to help. It might be a referral to the Ohio Lawyers Assistance Program. It might be a report to disciplinary counsel. You know, who wants to report their colleagues? No one. But you might actually be saving someone's life by doing it. So there's a lot of things that we could do to help improve the profession of our profession. I see him at 1 o'clock. Kevin, is that right?
Kevin actually had to hop off, but yes, it is
No problem.
correct. It's 1 o'clock, so we are about to start wrapping up. But I do just want to mention again, challenge word is Buckeye. You will be getting a survey from me as well as this presentation. Joe, if you could send this over to me, I can send it out to all attendees
Oh, great.
and
Yeah,
just
no
fill the
problem. If
survey out
anybody
for your
has
credit.
questions afterwards, my email's on the presentation. Feel free to contact me or use the attorney ethics hotline.
Perfect. All right. Thank you, everybody, for joining. We're going to wrap up. And again, you'll get that survey from me later today. Thank
Thank
you.
everyone.